Hey everybody, Matt Johnston here, Matt the lawyer. We're talking about contracts and we're talking about who has the power and the authority to sign those contracts. And when you're a small business, this can be very, very important. So before we get started with today's video, please do me a favor, click the subscribe button you see down there below. If you click the bell, you'll get a notice when we have uploaded new content. So earlier this week, a client contacted me and said, I've got a strange problem. Apparently, one of the employees at my client's office signed a contract with a third party, and it turns out that the employee doesn't have the authority to sign that contract. So we enter into kind of a strange sort of world where we talk about the law of agency. And it's a little academic, I understand, but essentially it boils down to this. For the most part, an employee of a company who is acting within their job description, within the scope of their employment, is acting as an agent for that company. Now, that employee may have certain powers, certain discretion, certain tasks that they are delegated to do, and they have the authority expressly delegated to act in such ways. And obviously, the higher you go up a management ladder, the more authority, the more discretion, and the more power that a person has. In some instances, the owner of a business may delegate express authority or actual authority to sign contracts on behalf of the company. An agent who signs a contract on behalf of the principal binds the principal to the contract. So, in other words, an employee who has the actual authority to sign contracts for the company has the authority, the actual authority, to bind the company to a contract. Now, if that authority is expressly delegated, it's a good thing. It keeps certain things off of the client, off of the business owner's plate, probably makes them happy, but it also comes with some caveats that you have to be very, very careful with. You need to be very clear with your employees, but also with third parties. The companies that you are signing contracts with should know who has the authority and who doesn't. You see, in the situation that my client was facing, this employee was relatively senior in terms of delegated authority, delegated powers, delegated job responsibilities, but was expressly told you cannot sign contracts for this company, period. But this employee signed the contract anyway. And the third party company, we're just going to go ahead and call them third party. This is the company that my client was contracting with. They didn't have any knowledge that the person who signed the contract didn't have the power to sign the contract. They're operating on what is known as apparent authority. From the appearances based upon job title, job responsibilities, the discretion that would be granted to this particular employee, the third party company probably reasonably thought this employee had the power to sign that contract. Now, the problem with it is that apparent authority can lead to a big dispute because the third party can say, wait a minute, you guys signed the contract. You guys are bound to that contract. I didn't know that person didn't have the authority to sign the contract. From all intents and purposes, it appeared they had the authority. Okay, that's where we get the apparent authority. Now you can sort of maybe start seeing what the problem is here. And the problem is that contract may not be what the principal, meaning the company, actually wanted. They may have wanted to negotiate the terms a little bit more. They may have wanted to reject the contract completely because maybe the terms aren't advantageous. Maybe getting out of the contract could end up being very, very expensive. And that's where you get into the question of apparent authority. It can lead to an actual contract being formed and being enforceable, and to break it means that you have breached the contract and you can run into some real expensive problems. So, how does a small business go about avoiding this? Now, oftentimes, very small businesses, 1, 2, 3, 4 employees maybe, they're going to know. But as your business expands, you're going to want to have some clear delegation that says you cannot sign any contracts, or you, the employee, can sign these kinds of contracts up to this amount of value. And then you also want to make clear when you're negotiating with third parties that the business owner has the only authority to sign the contract. And you want to put the other parties, the other contracting parties, on notice that the business owner is the only one that can sign the contracts. Or the business owner, can sign it, and this person over here can also sign it. But be very clear and make sure that that's in writing. The reason being is that a company who relies upon a signature they know is not authorized cannot make a claim later that the contract exists. So remember, your employees, when they're acting within the scope of their employment, they're agents of the company, and they need to know what powers they have. And you need to make sure that people outside the company have an understanding if it is relevant and if it's important. Now, if you have any questions about training people about these sorts of questions, or any sort of questions about actual versus apparent authority, please give us a call. We're happy to walk through any questions. In the meantime, go out and watch some live soccer. We'll talk to y'all later. Bye-bye.